Detailed case summary. The Nema, 1982, is a significant case in the field of English commercial and maritime law, dealing with the interpretation of force majeure clauses in charter party agreements. The central issue is the extent to which unforeseen events could relieve parties from their contractual obligations. Background facts. Claimant plaintiff, the charterer who rented the ship, the Nema defendant, the shipowner of the Nema. Background facts. The Nema was a vessel chartered under a time charter party agreement. During the charter period, a significant strike occurred, disrupting the operations at the port and preventing the vessel from being loaded as scheduled. The charterer sought to invoke the force majeure clause in the charter party agreement, arguing that the strike was an unforeseen event beyond their control that excused them from their contractual obligations. The shipowner, however, contended that the strike did not fall under the force majeure clause and that the charterer remained liable for the charter hire during the period of disruption. Argument in the court case. Plaintiff's argument. The charterer argued that the strike was a force majeure event as it was unforeseen and beyond their control, thus relieving them from their obligations to pay the charter hire during the period the vessel could not be used. Defendant's argument. The shipowner argued that the force majeure clause did not cover the strike and that the charterer was still responsible for the charter hire. They contended that the strike, while disruptive, did not fall within the specific terms outlined in the force majeure clause of the contract. Final outcome and legal justification. Final outcome. The House of Lords ruled in favor of the shipowner, determining that the strike did not qualify as a force majeure event under the specific terms of the charter party agreement. The charterer was held liable for the charter hire during the period of disruption. Legal justification. The court's decision was based on a strict interpretation of the force majeure clause within the charter party agreement. The key legal principles outlined in the judgment included strict interpretation of contractual terms. The House of Lords emphasized that force majeure clauses must be interpreted strictly and according to their precise wording. The specific terms of the clause must clearly cover the event in question for it to be invoked successfully. Burden of proof. The burden of proving that an event falls within the scope of a force majeure clause rests with the party seeking to invoke the clause, in this case the charterer. The charterer failed to demonstrate that the strike was covered by the force majeure provisions in the contract. Key concept. The Nema, 1982, case underscores the importance of precise and clear drafting in contractual agreements, particularly regarding force majeure clauses. It highlights the principle that such clauses must be interpreted strictly and that the burden of proof lies with the party seeking to invoke the clause. Key learnings. Force majeure clauses need to be clearly defined and precisely worded to avoid ambiguity. Parties must ensure that all potential disruptive events are explicitly covered within the force majeure clause to invoke it successfully. The burden of proof lies with the party claiming relief under a force majeure clause, and they must demonstrate that the event falls within the scope of the clause. This case illustrates the court's preference for strict interpretation of contractual terms to uphold the certainty and reliability of commercial agreements.